All rise. The Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable F. Ram Wallace, Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. We want to first thank the people in the local government of Clay County for having us here. It's a unique experience for us to travel and to be able to do these oral arguments in what we consider to be remote locations, not because you're far off, but you're far away from Daytona. So I want to first introduce myself. My name is Rand Wallace. I am a judge on the court. I live in Seminole County. Joining me on this panel today are to my right and your left, Judge Eric Eisnagel, also from Seminole County, and on my left and your right, Judge John Harris from Brevard County. Before we get started, I wanted to take an opportunity to thank the teachers, administrators that made this possible today, from Clay County Teen Court, Ms. Stacy Smith, and I don't know if Ms. Smith is here. There's Ms. Smith. And Jamie Davis from Teen Court. Teen Court is I see Ms. Davis. Teen Court is very near and dear to my family. My children participated in that in Orange County for years. They're older now, so those days bring back memories for me. And Clay County High School, Daniel Harris. Is Mr. Harris here? Thank you, Mr. Harris. If you could just make sure before we begin with the OAs, if you have any devices that make noise, cell phone, iPad, whatever, may distract the lawyers when they're giving their presentation, please either mute them or just turn them off. And the first case we have on the docket is Heather Washington versus ViStar Credit Union. Those lawyers can make their way to their tables. You can go ahead and do that now. And while you're doing that, just to let the students and the teachers know, after each oral argument, I'm going to give the lawyers an opportunity to introduce themselves to the students. And for any of you all who may have an interest in pursuing any type of legal career, hopefully when they speak to you, feel free to ask any questions. We will not answer any questions about the case, but any questions about background or how they got to where they are in their career, we would hope that the lawyers would provide some background, and maybe even some of the judges may provide some background to you as the cases go along. So in this case, do we have a cross appeal in this one? Just a second. Yeah, the second. Okay, so in the Washington versus ViStar Credit Union, for the appellant, it's Mr. Phillips, is that right?
Good morning, Lisa Lafanara. Mr. Phillips was unable to attend this morning.
Okay, and I'm going to assume that you'd like 5 minutes for rebuttal unless you tell us differently.
Yes,
is
please.
That okay? Okay, and so when you are ready, you may proceed.
Good morning.
Good morning.
May it please the court, my name is Lisa Lafanara, and I represent appellant Heather Washington in this matter. This case challenges the assessment of overdraft fees on debit card transactions that did not overdraw the account at the time the customer made them or ViStar authorized them, and for which there were always sufficient funds held in the account. The motion to dismiss at issue in this appeal can be resolved by applying basic and well-settled principles of contract interpretation. A contract that is subject to multiple interpretations is ambiguous. Ambiguous language is construed against here ViStar, the drafter of the party's contract. And of course, contract language must be construed in a manner that does not render any language superfluous or meaningless. The Circuit Court erred in applying these standards, and this court should reverse for 3 reasons. First, the trial court's decision ignores dispositive language in the contract that can only be read to mean that overdrafts occur at authorization. Second, at best for ViStar, the contract is internally inconsistent and ambiguous as to whether overdrafts are determined at the initial authorization stage or at the second settlement stage. Finally, the court did not meaningfully address appellant's allegations that there are always sufficient funds held in the account such that no overdraft occurs regardless of whether overdrafts are assessed at authorization or at settlement. Now, as an initial matter, it's important to note the procedural posture at which this case was decided. We're here on an appeal from a motion to dismiss. Therefore, for purposes of this argument today, it was not appellant's burden to demonstrate that she will prevail on her claims. It's simply her burden, or excuse me, it's the credit union's burden to show that there is no set of facts under which Ms. Washington may be entitled to relief.
Counsel, if we could, for benefit of, because of the setting that we're in here and the gallery we have with students watching as well, the facts of this case are your client appeared in front of a vendor and was using the debit card to obtain payment for goods and services, correct?
That's correct, Your Honor. Debit card transactions go through a unique 2-step process that no other transaction type undergoes. And that is at that initial stage when the customer is checking out at, say, a grocery store. She swipes her debit card for payment and the transaction is either approved or declined. That's what's referred to as authorization. And at that stage, if the transaction is approved, ViStar will place a hold in the account for the amount of the authorization and remove those funds from the customer's available balance so she can no longer use those funds for any other purpose or any other transaction. Then up to 3 days later, the merchant will present that transaction to ViStar for what's called settlement. And at that point, ViStar transfers the funds that were placed on hold to the merchant and the transaction finally clears the account.
What's the purpose of the authorization? Is it to protect your client or to protect the vendor?
I think it serves multiple purposes, Your Honor. It is a budgeting tool for consumers. They can look and see that the money that they've
Can you point to me in the agreement where it indicates that it's for the benefit of
There's no language in the agreement that talks about the purpose of the hold or the benefit that it serves. But I think from a common sense perspective, it benefits the customer as a account management device. It also protects the merchant because they can ensure that there are always sufficient funds. And it also protects ViStar for the same reason.
Once ViStar authorizes a transaction, they're essentially committed to making the payment later to that vendor. Is that correct?
That is correct, Your Honor.
So with the authorization, if we're only looking at the contract, and we're not speculating about what might make sense in the world, but if we're only looking at the contract, do you agree it's clear that the authorization is to benefit at least the vendor and ViStar, so that once the authorization happens, the vendor knows I'm going to get paid, and ViStar knows, hey, I set these specific funds aside so that the payment can be made?
If we're looking solely at the contract, unfortunately, this is another issue that's not addressed. But I would agree that from a common sense perspective, that yes, the authorization process does serve that purpose of protecting the vendor, ViStar.
How important is the definition of payment? I understand it's not a defined term.
Mm-hmm.
So let me say that definition. How important is the meaning, the contractual meaning of the word pay or payment?
So I think it definitely is relevant to the case. I don't think that it's as important as ViStar's brief makes it sound, and that's for a couple of reasons. First, as I mentioned, there is unambiguous language in this contract that requires overdraft determination to happen at that authorization stage. So for example, if we look at page 77 of the record, there the contract provides a basic overview, the primary overview of the courtesy payment or overdraft service at issue in this case. And it says, quote, "This service allows us to authorize payment for the following types of transactions, regardless of whether your account has sufficient funds." And in sub 4, it shows ATM and one-time debit card transactions. So that language can only be read to mean that courtesy pay is triggered at the time that ViStar authorizes payment. Similarly, on page 78 of the record.
Would that be exclusive though? I mean, I'm just assuming that we agree with your interpretation of that particular language. Would it be exclusively how an overdraft would occur?
I'm not sure I understand your question.
Would it be the only way an overdraft could occur?
If we were to read that provision, it does say that overdrafts are assessed, or at least ViStar is determining, quote, whether the account has sufficient funds, end quote, at the time that ViStar authorizes payment. There is no language in that provision that would authorize ViStar to determine overdrafts at the second settlement stage. Similarly, on page 78 of the record, the contract says pending transactions and holds placed on your account may reduce your available balance and cause your account to become overdrawn, end quote. Here, there is no dispute that these holds occur at the authorization stage. And so ViStar's interpretation that it's only the settlement of these transactions that can create an overdraft would render this language entirely nonsensical.
Well, I guess my question is, why isn't it both? Why can't there be an overdraft both at authorization and at the later settlement or payment?
Well, the problem, Your Honor, is that the contract doesn't say that. It says in some places authorization, or when pending transactions and holds are placed, and it uses that language in those provisions exclusively. In other places...
Well, hold on. Can I just point out some language in the contract then?
Of course.
Section 14A, the first sentence. An overdraft occurs when you do not have sufficient available balance in your account to cover a transaction at the time it is presented to us for payment, but we pay it anyway. Why does that have only the meaning that an overdraft can only occur at the time of authorization?
So appellant suggests that that language is ambiguous because debit card transactions, as I mentioned, are presented to ViStar twice. First at authorization and second at settlement.
But not for payment. It's not presented to them for payment twice.
Well, that depends on the meaning of payment within this contract.
It does, so that's why I asked you how important payment is.
Yes, and again, Your Honor, we agree that it's certainly relevant to the parties' dispute, but it's not dispositive. The problem is ViStar relies on payment and the term pay throughout the contract to argue that settlement is the only time at which overdrafts may be assessed, because again, it's ViStar's burden on this motion to show that that is the case. But that language, first and foremost, cannot be squared with the language that we've already discussed that talks about overdrafts occurring when ViStar authorizes payment, or that pending transactions and holds causing an overdraft.
But see, so authorizes payment, that seems like a different, that seems to have a different meaning to me than payment. Authorizing payment would be the authorization, right?
Mm-hmm.
That's not the same thing as payment. You agree with that? Authorizing payment is the authorization, as I'm reading it.
Authorized payment, I agree, is authorization.
So then payment would be later on when ViStar actually pays the amount over to the vendor.
So two responses to that, Your Honor. First, within the language in 14A that talks about authorizing payment, that language unambiguously talks about ViStar determining whether your account has sufficient funds at the time that it authorizes payment. So this idea of pay doesn't come in until we start comparing the different provisions and the way that they talk about this differently, which appellant suggests creates ambiguity. But second, as ViStar concedes in page 19 of its brief, pay is an undefined term in this contract. And the problem is that payment is used inconsistently throughout the contract and with different meanings, which by definition creates ambiguity.
But you agree that when the contract says authorized payment, that's not necessarily the same thing as pay or payment. Those are two different things. You agree with that?
I think they could be. I think
those two things. In other words, if the contract in one place says authorized payment and then another part says pay, those aren't necessarily being used inconsistently because they're two different things.
Not necessarily. I agree that it's possible. However, again, there are different provisions that we've discussed. There's language about pending transactions and holds causing overdrafts. There's also language on page 86 that says if you initiate a transaction that overdraws your account, you agree to make immediate payment of any overdrafts together with any service charges. Reading payment to unambiguously mean settlement in that context simply doesn't make sense. It would say, if you initiate a transaction that overdraws your account, you agree to make immediate settlement of any overdrafts together with any service charges. There's no dispute here that the customer has no control over the settlement process, no involvement in the settlement process. And so reading pay in that context to mean settlement simply doesn't work.
I'm sorry, I'm not following that. Can you go over that? Why in that sentence? Just make that argument for me. I'm just not following.
Certainly, Your Honor. So there's no dispute here that the only point at which a customer initiates a transaction is at authorization,
Correct.
right at the time that she's at the grocery store checking out, for example. And so here when it says, if you initiate a transaction that overdraws your account, you agree to make immediate payment of overdrafts together with any service charges. So a reasonable or appellant would submit the only reasonable interpretation of that language is that ViStar is determining whether an overdraft or a service charge would be assessed at the same time that the customer is initiating payment, as this provision says that payment is immediately due after initiation.
I mean, it's not, okay. I'm not sure that's as clear as, and I've read it, but I'm not sure that's as clear as I'm not sure I entirely agree with you there, but okay, go ahead.
Well, similarly, Your Honor, the other issue is that payment throughout the contract is used in reference to the time that ViStar exercises its discretion to pay or decline payment or return.
It doesn't seem like that's what 14A does, though.
Not in 14A, but of course payment, for it to be an unambiguous term, it has to be used consistently throughout the contract.
Or we have to be able to read it all in context and read it together, right?
Certainly, but the key provisions that ViStar is pointing at, for example, in 14A, if we go down a little bit further from where Your Honor was just reading, it says your account may be subject to a charge for each item regardless of whether we pay or return the item. So there, the contract is linking the charge for overdrafts to the time that ViStar either pays or returns the item. Now that language is crucial here because there's no dispute between the parties that the only stage at which a debit card can be either paid or declined is at that authorization stage. As we've discussed, once a debit card transaction is authorized, ViStar loses any discretion to decline payment at settlement, and it must settle the charge. So again, within that context, the term pay in the context of assessing overdraft fees reasonably refers to authorization. But Your Honors, there's a second reason, and an independent reason, for which the Circuit Court erred in dismissing appellant's claims. And that is that there's this language in the contract that promises to place authorization holds, and those holds reasonably protect against overdrafts at the settlement stage. So the parties here agree that the contract unambiguously requires ViStar to determine overdrafts based on the account's available balance. The available balance is different than the amount of money that the customer actually has in her account because it is reduced to reflect holds for pending transactions like the ones at issue here. Similarly, the contract is clear that these holds are placed at the authorization stage. So appellant alleges that she reasonably understood that if there were sufficient funds in her account at the time she made the transaction, those funds were immediately placed on hold, and those funds were no longer available for any other transaction, and that hold remained in place until the transaction settled, then those funds must remain in the account to settle that transaction.
And that, under that theory, that wouldn't always work, right, for every transaction. Sometimes a transaction is authorized for a certain amount, but then it comes through for a greater amount, correct?
That's correct. There are circumstances.
So your reading would work maybe for most, I assume most transactions, but not all. Do you agree?
I agree that it's a complicating factor, Your Honor. There are certainly cases.
What would happen with your interpretation of that language, what would happen in the circumstance of, the classic, right, the authorization for a meal, and then you leave a tip, which is not on the authorization, so the amount comes through for whatever, $20 more than what was authorized. Under your interpretation of the language, how does that work then?
So, Your Honor, if a transaction overdraws the account, under this timing argument that appellant has put forth, there would be an overdraft regardless of the amount of the transaction at settlement.
So the overdraft would occur at payment then?
It would occur at the time of authorization.
Well, how would it occur at authorization because the $20 wasn't authorized?
So the amount, if the transaction creates an overdraft at authorization, it gets a fee. If, say, the customer has $50 in her account, she buys a $40 dinner, and then adds a $10 or a $12 tip, right? So the authorized amount is for the $40. There's no overdraft at authorization, so there should be no fee. If there's a countervailing example that ViStar has put forth.
But there would be, so you're just saying there would be no fee because at authorization, there's no overdraft.
That's correct.
So even though, theoretically the cardholder then leaves a $1,000 tip, no dice for ViStar. Too bad, so sad.
Under the contract language in this case, that's correct, Your Honor. And I know that seems a little counterintuitive, that may even potentially seem unfair, but Your Honor, that is a...
Well, we're not concerned about what's fair, we're concerned about what's in the contract. I guess the question is, does the contract support that?
Exactly, Your Honor. And again, it says that overdrafts occur when you initiate transactions, when ViStar authorizes payment, and that pending transactions and holds are what cause overdrafts. And so that...
Which provision is that you just quoted?
The language about causing overdrafts?
Yeah, were you quoting language there or were you summarizing it?
I'm summarizing. So there is language it's on page 77 that talks about if ViStar authorizes payment. On page 78, it says in section 14C, pending transactions and holds placed on your account may reduce your available balance and cause your account to become overdrawn regardless of your actual balance. And then on page 86 of the record, Your Honor, is the language that says...
I guess, why does it, just because a hold could theoretically cause an overdraft depending on how things come in and the timing, why does that necessarily mean an overdraft is only at the time of authorization and can't also be at the time of payment? So in other words, if there's $1,000 worth of holds at any given moment, and then the timing of things comes in and there's a transaction or a check that now will overdraw, considering the holds, will now overdraw the account by some amount, right? Mm-hmm. Why is that so calculating it based on at the time of payment? Why doesn't the contract call that an overdraft?
So the check would incur an overdraft fee if it is presented when there are insufficient funds, even if there would be
considering holds.
Even if the only reason there are insufficient funds.
But you're saying not the card. The check would, but not the card.
That's correct, Your Honor, because in that situation...
Can you point me the language in the contract that ties that in a bow for us?
Unfortunately, there is no language in the contract, and that's part of the issue here, is that it is fundamentally ambiguous. And so for those reasons, Your Honor, we would ask the court to reverse. Thank you.
And I'm assuming you are not Sarah Holliday.
That's correct, Your Honor.
Okay.
I'm Jason Bowyer. I'm here with my co-counsel Stuart Richter and Pat Gibbons.
Okay, you may proceed.
May it please the court, Stuart Richter from Katamusha and Rosenman, Pro Hoc Vice, and I'll be handling the oral argument today. Honors, this, as you pointed out, is a breach of contract case. And the contract is attached. There's a version of the contract attached to the original complaint, and there's a version of the contract attached to the first amended complaint.
Is that the difference between the 2019 and 2020?
There's very little difference, Your Honor.
Those are the two contracts you're talking about?
Yes, Your Honor.
Is there agreement as to which one controls?
The 2020 version attached to the first amended complaint should control because it's alleged in the complaint, both the original and the first amended, that Ms. Washington, the plaintiff, incurred overdraft fees in 2019 and 2020. I believe her account was overdrawn and charged off by the time the 2021 version of the agreement took effect. So my argument today will be focused on the 2020 version, but again, very little difference between the two documents.
It's an important, counsel, that we're here at the motion to dismiss stage of this case and not at the stage of motion for summary judgment or trial.
That is important, Your Honor.
How so?
Well, because this court has to accept allegations in the complaint as true. However, because the contract is attached to the complaint, to the extent those allegations are inconsistent with the terms of the contract, the court should accept the terms of the contract if it's unambiguous. And the circuit court in this case, Your Honors, found that this contract is unambiguous, went on to read the meaning of that contract, and found that the unambiguous terms of the contract are inconsistent with the plaintiff's allegations, and rejected the plaintiff's
We're not bound
allegations.
by the circuit court's findings on that, correct?
Correct, Your Honor, this is de novo review.
So let's get to it.
Thank you, Your Honor. Plaintiff alleges that for debit card transactions, and specifically signature debit card transactions, there's two types of debit card transactions. One is a PIN transaction where you punch in your PIN number. That's like an ATM withdrawal. Authorization and payment occur.
We're talking about signature, right?
Yep,
So
we're
let's talk about
talking
those.
Signature debit card transactions occur in two stages, and that's spelled out in the contract. Plaintiff alleges that for signature debit card transactions, unlike all other payments, checks, ACH payments, PIN transactions, the credit union must determine whether there's been an overdraft at the time of authorization as opposed to the time of payment, when money actually leaves the account. That's payment. Now,
That's what plaintiff alleges.
that's what plaintiff alleges.
We take that as true.
No, because the contract doesn't say that, Your Honor.
Point to that. Where does the contract refute that allegation?
Justice Eisenagel pointed to the first section, section 14.
Just for the record, I'm not getting a promotion here, I'm a judge.
Judge, I'm sorry.
That's right.
Judge Eisenagel pointed to the section that deals with overdrafts in the contract. Plaintiff consistently referred to it at page 77 of the record. That section is called overdrafts. And the first part of that section describes what an overdraft is. And it says, if on any day the available funds in your account are not sufficient to pay the full amount of a check, draft, transaction, or other item, all types of payments, if there isn't enough money in your account to pay the full amount of a transaction, we may return it or pay it. And it goes on to describe when an overdraft occurs. And an overdraft occurs and can only occur when a transaction is paid. If I have $100 in my account and a check is presented that I've written for $120, if the credit union does not pay that transaction, if it rejects it or returns it as stated here, there's no
So
overdraft.
counsel, under that factual scenario, there's been talk about authorization or approval, which is also a stage of the operations contract. You would agree, correct?
Yes.
Under the factual scenario that you are now giving us, that renders the use of the word authorization irrelevant or really utterly useless. Authorization means nothing under this transaction. It all focuses on the point of payment or the time of payment, correct? What is the point to even having the word authorization anywhere in this contract?
I'm going to take issue and disagree with that, Your Honor. For every type of payment transaction, there is authorization and then there is payment. Sometimes authorization happens almost the same time as payment. When a check is presented to the credit union, if there's not enough money in the account and it's not authorized, it is returned unpaid.
But we're not talking about a check here. We're talking
Yeah, let's focus on the
about a
signature.
card. We're talking about putting the card into a machine, and on the screen, I believe, the words will be authorized or approved. And at that point, the consumer then takes the goods and services, and then that is the end of the transaction for purposes of the provider and the consumer. You would agree?
Not for the provider, for the consumer it is.
Well, the provider then can sit on it, apparently according to the factual scenario both parties were laying out, the provider can sit on it for 1 to 3 days before they even process it towards the bank, correct?
Provider can sit on it for 6 months. The 3 days is just the limit when that hold, that authorization hold that counsel was referring to, that drops off the account after 3 days.
Well, let me just make sure I understand, because it is important that the term authorized means something. And so I think Judge Wallace has brought up an apt point here. If at the authorization phase, the card goes into the scanner, the signature card we're talking about, and it comes back declined, not authorized. What happens versus when it's authorized? What happens?
If the transaction is declined, nothing happens. If you're standing in the grocery line with all your groceries and you swipe the card and it's declined, the groceries go back on the shelf.
There's no transaction.
There is no transaction, and you are not charged a fee for a debit card if it's returned. And the reason I bring up all these other transactions, Your Honor, is because this section defining overdrafts talks about all types of payment transactions. And my point, Your Honor, is in order to have an overdraft, regardless of the type of transaction, there has to be payment out of the account. The account has to go negative. That's what Section A under overdrafts says. You can't have an overdraft unless your account goes negative. Hence the term pay. When we pay, not when we authorize. There are 2 stages for signature debit card transactions.
I guess my question was maybe a little off then to your opposing counsel. Perhaps the authorization maybe does have some benefit for even the customer, the cardholder, because if there's not an available balance and the transaction is declined, they avoid an overdraft. Is that correct?
That is correct.
Okay.
And that's what the second section, the courtesy pay section, that counsel referenced, that's what that refers to. That's where, for all types of transactions, again, ViStar offers a courtesy pay service. Basically what that means is, if your check, if your debit card is swiped, if your ACH, your power bill, tries to get paid through your checking account, and you don't have enough money, the credit union may authorize that transaction, and will subsequently pay it, may authorize it, because you have courtesy pay. As a courtesy, you authorize it. The difference between an overdraft and a transaction being rejected is important, because the ViStar fee schedule is Exhibit B to the First Amendment complaint. It distinguishes between the two. If your transaction, your check or your ACH is returned unpaid, you get a $32 fee. If ViStar pays it under this courtesy pay section, if your account goes negative by more than $5, you only get a $29 fee.
Can I ask you about an argument that your opposing counsel made here in the same 14A? It's farther down. And there's some merit to what she said. This sentence doesn't seem to really fit to a signature card transaction. Seems like it's probably more directed to like a check or the PIN card transaction, but I'm interested in what you think here, that your account may be subject to a fee for each item regardless of whether we pay or return the item. That doesn't seem to apply. That sentence doesn't seem to apply to a signature card transaction at all, but I want to see what you think, and when does that apply? What does it mean?
Yeah, and again, Your Honor, this goes back to what I just said. This paragraph deals with all kinds of overdrafts, and so in the situation where I've given my checking account to the power company and they initiate an automatic clearinghouse transaction, take money out of my account, if there's not enough money and they've done the transaction, ViStar rejects it or returns it and will charge a non-sufficient funds fee. That's $32. If ViStar pays it as a courtesy, that's an overdraft and you get $29. Unlike an ACH or a check, you are correct, Your Honor. If a debit card transaction is declined, it's just declined. It's like you're at the ATM. You don't have enough money? Say no. There's no fee. And that's dealt with later in the contract under the section that specifically addresses signature-based debit card transactions, the appellate record on page 78, where it describes this 2-step process and how it works. So there it says that a merchant may seek authorization for these types of transactions, signature debit card transaction.
Can you tell me again where you are on 78?
It's Your Honor, at the bottom of page 78.
D what?
D, well, it doesn't, it's a bullet point, signature-based debit card transactions.
Thank you. Go ahead.
See, this section describes all the various types of transactions and how you can get overdrafts. It's in the overdraft section. So it says merchants can seek authorization for a signature-based debit card transaction. The authorization requests place a hold on funds in your account when it's completed. The authorization hold will reduce your available balance by the amount authorized, but will not affect your actual balance. Goes on then. The transaction is subsequently processed by the merchant and submitted to us for payment. Going back,
The word transaction has been used a lot by you in your presentation, and I just want to clarify for my purposes, when you talk about transaction, you're talking about the transaction between the vendor and the consumer. Or are you also talking about transaction as to when the payment is made and when the account is settled?
it's both, Your Honor. The transaction is a payment transaction initiated by a consumer to pay a vendor. That's a transaction. For debit cards, there's a two-step process. There's that authorization, as I just noted in this section, at the time the card is presented, and later, when the merchant, through the debit card system, the Visa MasterCard system, through that system, asks for final payment. And that's important, Your Honor. You brought up some examples, because this section goes on to say, the amount of an authorization hold may differ from the actual payment because the final transaction amount may not yet be known to the merchant when you present your card for payment. So, although payment is not a defined term, this section describes what payment means. Payment is when the merchant submits through the system to get its money. That's when the money.
Relevance of the reasonableness of plaintiff's interpretation of the contract when there's an ambiguity.
There should be no relevance to the plaintiff's interpretation. This is the objective theory of contracts.
So if each side has a reasonable interpretation of what this contract says, does that make it ambiguous? Are there cases that would say it's ambiguous?
If each side, if this court overturns the circuit court's decision, the circuit court said it's not ambiguous and the plaintiff's interpretation is not reasonable. If this court believes on de novo review that what the plaintiff argued is reasonable in light of the language in this contract and we disagree, then yes, that would render the contract ambiguous.
And we would reverse.
I would assume so, Your Honor.
Okay.
And again, I don't see how you can do that because the district court's interpretation is consistent with this language. And I'd like to point out a few other provisions in the contract, if I may. First of all, pay, although again it's not defined, it's described, that process for signature debit card transactions. And the agreement refers to when we pay. We is a defined term. We is the credit union. We is not the plaintiff when she presents her card at the grocery store. When we pay. Second, Your Honor, you raised the issue, and it's addressed here, about how the authorization may differ from final payment and the restaurant situation. And again, it's referenced here in the contract. If you use your debit card at a restaurant, it describes that. It also mentions gas stations, and that's a particularly appropriate example of why the plaintiff's theory here is not reasonable. Suppose I go to a gas station, and as you said, I put my card in, and it says approved. Now, given the high price, say I have $40 in my account. Given the high price of gas, my card is approved. It's authorized for $50. I have $40. Authorized for $50 because I have courtesy pay. The credit union is going to authorize it even though I don't have enough money. My intention at the pump is to pump $20 worth of gas so I don't overdraft my account. because as plaintiff's counsel pointed out, I looked at my phone, I know I have $40. I pump $20 worth of gas. So authorized 50, I pump 20. Under the plaintiff's theory, I'm going to get a fee, even though I never paid more than I had in my account.
Even though you never intended to spend it.
And I never intended to spend it.
But because the merchant put an authorization, by the way, that happens, the contract lists several places, but obviously it happens more places than just that. Hotels, and the contract says hotels routinely put a large authorization through to cover just for damage to the hotel room, right? Something like that.
Raiding the minibar.
But there's no way anybody could be confused about that because all that is expressly in the contract.
Yes. It's all in the contract. And there's one other provision that plaintiff's counsel, I don't know my time, there's not a timer up there, but
2 minutes and 30 seconds.
okay, I can get through this. Plaintiff's counsel referenced the section on page 78 at the top called Understanding Your Account Balance. Again, this is all in the overdraft section, trying to explain where you're going to get a fee. And so what this section, the beginning of it, talks about is there's two balances, the available balance and the actual balance. The actual balance is the full amount of all your deposits less payments that are actually processed. The available balance is your actual balance less holds on your account. For example, an out-of-state check, you only get $200 right away. Debit card holds. There could be administrative holds for garnishments, things like that. Available balance. And it says, we use your available balance to determine whether there are sufficient funds in your account to pay items, including checks as well as ACH, debit card, or other electronic transactions. It goes on to say this, and this is what plaintiff's counsel quoted. Pending transactions and holds placed on your account may reduce your available balance and cause your account to become overdrawn regardless of your actual balance. The plaintiff says, well, that means the debit cards themselves cause the overdraft. I would submit that that just means your available balance is reduced, and if you present a check or anything else and there's not enough available balance, you're going to get a fee.
Well, 14A says that an overdraft is based upon the available balance, right? Payment, and you look at the available balance. So if we read it all in context, that sentence is reference to the available balance is just like 14A, right?
That's right. But there's another sentence that is not in the contract itself, but the court considered because the court granted judicial notice of an amendment to the contract that was made in April of 2020 during the time plaintiff got her fees. So the contract as amended said, pending transactions and holds placed on your account may reduce your available balance and cause your account to become overdrawn regardless of your actual balance. The next sentence after the amendment says, in such cases, subsequent posting of the pending transactions may further overdraw your account and be subject to additional fees.
Counsel, you're in.
Yeah, that's an APSN transaction. It says it right there, you're going to get a fee for it. Thank you.
Counsel, before you get started, I had a question. I believe you made an allegation in your brief that there was extrinsic evidence that was relied upon by the trial court in rendering a decision. What extrinsic evidence did the trial court inappropriately rely upon?
So if I understand your question, Your Honor, I believe it's referring to the trial court's reliance on dictionary definitions of the term pay. And of course, dictionaries...
Counsel, we use dictionaries all the time.
Certainly, however...
That's not really extrinsic evidence.
Well, certainly, however, the point that we were making in the briefing is that cannot override the contractual meaning of a term, particularly where the contract in the surrounding context would render that provision meaningless.
I have a question for just clarity as well, and I'm happy to give counsel an extra minute or two, but your brief talks about at certain places that just the situation is unfair, and it may well be. I don't know, but I want to make clear, you don't have an unfair and deceptive trade practices claim, right? This is just a straight contract claim.
That's correct, Your
So
Honor.
fairness really isn't an issue.
That's correct. For both parties, what should be the case is not an issue, just that the parties actually agree. And if you look at what the parties actually agree at, I'd like to start with section 14D on page 79 of the record. We just heard Mr. Richter say that this last paragraph is where ViStar explains that payment means settlement. But the very sentence that Mr. Richter stated uses payment to mean both settlement and authorization. It talks about actual payment being different from the time of the authorization hold. And then it also talks about when you present your card for payment. Again, there's no dispute that the customer does not present her card at settlement. Similarly, we heard that it always refers to ViStar's payment. I would direct the court's attention to page 86 of the record, where it says, if you initiate a transaction that overdraws your account, you agree to make immediate payment of any overdrafts together with any service charges.
Isn't there, counsel also argued, and that seemed like a good point, that we pay versus you pay, those seem to be completely different things as well.
Well, they can be, but Your Honor, the issue is the contract talks about overdrafts in context of both we pay and you pay, and that creates ambiguity. Finally, with respect to this 2020 amendment, there are allegations in the complaint that predate that amendment, and so dismissal on that basis would be improper with, at minimum, with relation to those allegations.
What's the key provision between the two, the original and the amendment? What's the key difference that we should look at for that?
I think for purposes of this dispute, the difference doesn't really matter. The only issue is with the April of 2020 amendment that adds the language saying, in such cases, subsequent posting, the language that Mr. Richter quoted there. I think that also falls flat for two reasons. The first being it says that it's added to the second paragraph of section 14C. 14C is only a single paragraph, so already there's confusion about where that language goes. Second, it talks about in such cases, which reasonably refers back to the pending transactions it holds that overdraw the account. That reasoning is further consistent with the language saying posting may further overdraw the account and be subject to additional fees. A transaction cannot further overdraw the account unless it previously overdrew the account. And so, Your Honor, we respectfully ask this court to reverse. Thank you.
Thank you. Thank you, counsel. Case was well argued on both sides. And now I'm going to invite counsel, first starting with the appellant, to please introduce yourself to the gallery.